fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't even gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances. The testimony from the defendant is George Torres' head is here. You can stand if you need. You've been sitting a long time too. His head is here. His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back are on his left side. You hear that? That's solid. You don't have to accept that she put those marks on him while he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase. You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her 2 neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this. Do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happened outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't. The inconsistencies, I'm not going to belabor it. Your dinner is waiting in back. Let's just briefly talk about the experts, and we'll move on to the end. Dr. Brandon was absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, "Dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you?" It's like, man, I'm not a beefcake. I'm not going to rat her out. There's countless examples, if you apply Dr. Brandon's testimony to Juan Torres, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Miss Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power, to stop him from dying, because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop, and she didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story, and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Miss Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. Again, it's not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes. And you'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
Thank you both. Members of the jury, I have some additional instructions to read to you. If you would be so kind to turn to page 21 of 22. Instruction 3.12, verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. If you're looking for it, you don't have it. I do. That's why we only have one. The verdict form reads, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, case number 48-2020-CF-002603-0, State of Florida Plaintiff versus Sarah Boone Defendant. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank day of blank, 2024, signed, the foreperson. The final instruction, members of the jury, page 22. Instruction 3.13, submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. All exhibits, with the exception of Exhibit 10, which purports to be a wooden baseball bat, will be sent into the jury room with you when you begin to deliberate. If you wish to see Exhibit 10, which purports to be a wooden baseball bat, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Parties approach. Members of our jury, I want to take a moment and thank you for your time, your service, and your participation in this very important process. As I said to you last week, be it Monday or Tuesday, maybe even on Wednesday, without your sacrifice and your service, the wheels of justice would simply come to a screeching halt. And on behalf of myself, the state, the defense, and Ms. Boone, we thank you for that sacrifice. With that, jurors wearing badge 295, 9, 569, 515, 130, 249, and 448, and 110. You've successfully served as our alternate jurors in this trial. I wish I could give you more than my thanks and a hot meal that's waiting for you, but I do thank you for your service and your sacrifice. Courtroom deputy is going to take you out at this time so you can collect your meal, and I'll meet you back there momentarily to give you your jury certificates. Thank you for your service. The rest of y'all, if I didn't call your badge, you need to hang out. Thank you. All may be seated. For you 6, you are that will be deliberating in this case. I thank you again for your time and your service. The exhibits will be brought back to you momentarily, and a meal is waiting for you. We will work till approximately 10 o'clock tonight if you do not render a verdict before then. And I thank you again for your time and your service. I'm going to ask the courtroom deputy to go ahead and take you back now to the deliberation room. You can bring your phone with you. There's a basket that the deputy will take and collect for you. Thank you. Deputy. You all can be seated. Thank you very much.
May I raise something real quickly? Did you intend for the jurors to take the notes into the deliberation rooms?
Yes.
Okay, I would object to that on the grounds that it allows one juror to potentially assert that their notes are better than others as opposed to just relying on their memories.
Any response, State?
That's not the law.
There's a verdict form, there's an instruction that I read specifically on that, sir, that no one juror's notes should trump another juror's notes or their memory. So your objection is overruled. Mr. J and/or Mr. Cacciatore, do you have the clean laptop for the review by the defense? And while we're putting that together, can both the state and the defense review all exhibits that were entered into evidence and confirm they are what they purport to be, so that all exhibits that were entered, with the exception of Exhibit 10, the bat, would be sent back to our jury? Yes, please. Okay. I'm going to go speak to the alternates, and I'll return this momentarily. Thank you. Good. Thank you. All right, we're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record. Defense.
James Owens from Miss Boone.
I have the parties had the opportunity to review and inspect all the evidence to be sent back with the jury.
The defense has as best as I could.
Okay.
Yeah. I didn't keep a tally, so I trust the clerk's numbering system.
Madam Clerk is the best, so I have no doubts that everything is included. State, had the opportunity to review it?
Mr. Cacciatore was the person who did that, so I think so.
Okay, all right. And with regard to the laptop, has it been inspected?
Yes. Yes.
All right. Okay, so we'll send the exhibits back with the exception of Exhibit 10, the bat, and the clean laptop to our jury. Ms. Boone, I've got a couple of questions to go over with you again, ma'am, if I could. Ma'am, you were sworn previously this morning. You've been present throughout the entire trial, starting last week through today. You've been seated next to your lawyers at counsel's table. You've had the opportunity to observe the opening statements, the direct examination and cross-examination of all the state's witnesses, the direct examination and cross-examination of all the defense witnesses, and the opening or the closing statements as well that were presented by both sides. You've also had the opportunity to observe all of the exhibits that were presented as evidence in this case. Are you satisfied with your lawyers up and until this point?
Absolutely.
And are you in agreement with the strategy utilized in your defense?
Yes.
All right. The last issue that I need to address is the state's request for in-camera hearing regarding financial arrangements between defendant and defense team. State, what is your concern?
It's a very expensive defense, and she's indigent, and there are bar rules that limit the ways that things can be done. I don't know what's going on. It's none of my business unless it's raised in the 3850, so if there's an in-camera proceeding, I would ask to be sealed, and there won't be any need to get into it unless there's a 3850 claim that there's a conflict of interest.
Is there anything other than concern or speculation that you have?
Just things in passing that have been said and observed. It's very expensive defense. That's my concern. I don't want her to be able to raise any arguments that, well, I would have pled if I had a conflict-free lawyer who did not want it to go to trial for his or her own reasons.
Okay. Mr. Owens, is there anything of concern that I need to be aware of in camera?
No, sir. And
Mr. Henderson, same question to you, sir. Is there anything of concern that I need to be aware of in camera or otherwise?
No, sir.
Mr. Beck, same question for you. Is there anything of concern that I need to be aware of, be it here or in camera?
No, Your Honor.
Okay, all right.
Judge, and if you need to inquire from my client about whether or not she wanted to enter a plea or whether she wanted to go to trial, but we made it clear that it was her decision, not my decision to go to trial because I'm trying to gain some publicity or money or book deal or whatever. But that was her decision. There was some strong conversations we had about what was on the table. And Ms. Boone, as she has a right to, wanted a trial.
Mr. Henderson and Mr. Beck, would you agree with Mr. Owens' recitation as to none of the financial issues being book deals or anything on the table at this point in time?
Judge, yes, because I definitely don't know about it.
Okay.
Because
Mr. Beck, anything to add, sir?
Only, Your Honor, that I believe this is attorney-client privilege information, but there are no concerns about comment.
I colloquied Mr. Owens, your client, before we picked a jury as to the offer in this case and whether or not she was ready and wanted to proceed to trial, and she had affirmed at that point in time that that's what she wanted to do. So I see no reason to inquire of that further. State, is there anything else we need to address? Defense, anything else?
No, sir.
All right, please give your cell phone numbers to Madam Clerk. We will be on verdict watch. And I thank you all for your hard work in this case. We're off the record. instruction, talking to
from the
to be an expert. Like other witnesses, for its testimony, rules to consider. It is entitled would give if called to the his or her testimony of any witness. Each your verbal instructions.
On behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is similar, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So, as we start out here on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because George Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs, and it reads, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident, and the misfortune in doing any lawful act by lawful means, usual, ordinary caution, and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when George Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. George Torres couldn't provoke anything from his circumstance. George Torres was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, the killing is not done in a cruel and unusual manner. Well, this fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking and we're all having fun when she decides that it's going to get a little extra real for George Torres. And it fails on the 2nd count because George Torres was killed in a cruel and unusual manner. Next, we turn to our main charge, second degree murder. And the law informs us that to prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of second-degree murder. Those elements beyond all doubt. As to the first fact, that George Torres is dead, well, we have a stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. And it's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or a series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays an indifference to human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you, IMG 1062, the states 17. Mr. J, may you publish states 17?
Shallow. For everything you've done to me. Shallow. For everything you've done to me. Shallow. Fuck you. Shallow. Fuck you. Shallow. Stupid. Shallow. That's my name. Don't wear it out. I can't fucking breathe, babe. Seriously. Yeah, that's when you do and choke me, Cheryl.
Yes, did you do well?
You may continue.
Cheryl. Cheryl. Cheryl, I can't breathe, babe.
That's on you.
Cheryl, I can't breathe.
It's on you.
Cheryl.
Real ransom. Now you want to give it for it extra.
Because I got this. Sarah. Regular. Sarah. I can't breathe, babe. Oh. That's what I feel like when you cheat on me. Sarah. Fuck you. Breathe, Sarah. Yeah. You should probably shut the fuck up.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions. But we know from the evidence that this was not the first time she had considered killing George Torres. We know from the evidence that on January 13, 2020, approximately 1 month prior to George Torres' murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. And bless you and all of you too. I'll get rid of him. Then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that George Torres was murdered, and that maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine, with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise, and he is going to show you this. And this. And this. And he's going to talk, and this as well, about the list of grievances that Sarah Boone had for George Torres. He's going to talk to you about curtain rods. He's going to talk to you about black eyes. He's going to talk to you about what an awful, awful boyfriend George Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us, in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it. Hide and go seek time. George gets into the suitcase. She comes and zips him up. They were still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. He couldn't exert anything, ladies and gentlemen. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his...
Judge, I object.
Approach. Objection overruled.
This is of no help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything. George Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the special instruction on battered spouse. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we've heard from three experts in the areas of battered spouse in this case. And I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that George Torres at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did these awful bad things, that now through the rest of time she's a battered spouse and she just has the right to kill him, or to make him suffer, or to punish him, or to make him feel uncomfortable, or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does is it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical. Dr. Brannon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony, because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. And her opinion was much more straightforward. Remember, Dr. Brannon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brannon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on, meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's a reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because George Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
I'm going to go to court and I'm going to tell the judge, listen, my fiance has nothing to do with this. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Her being in trouble in her life, she has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments. But we are not the type of people that you guys are portraying us to be.
She especially.
Especially her. So please, if you can,
Dismissed.
dismiss this case.
Closed.
Drop it. She is not the type of person.
Good person.
She's a great person.
Angel.
I know she'd be an angel. But she's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet.
What?
And it good.
I love you, baby. Whatever you want me to say. God will prevail and will take us out of this situation. Love you.
Clearly, George Torres is dominating the defendant. Clearly, George Torres is the one telling the defendant what to do. Clearly, George Torres is the one calling the shots at 47-48. France Lane. Ladies and gentlemen, are we so sure that George Torres wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed that the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing George Torres, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, they published from States 17, IMG 1063. It was a short video. But what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later, from the time that started, you see that the makeshift coffin that he's in has been moved. And his voice now is softer. The life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only George Torres in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. George Torres and Sarah Boone. But only Sarah Boone ever walked out of that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not George Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next Interview the next day with Detective Copsell and Detective Lowen, and more details come out. Things change. First, she was never intoxicated, then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt when she described using that baseball bat to hit George Torres's fingers back in the suitcase when he attempted to save his life? Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of George Torres being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone? After seeing the videos of how she controlled and manipulated George Torres? And if you say, Mr. Cacciatore, I still have a doubt, well then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt? A speculative? An imaginary? Or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions, and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. And do not have any discussions among yourselves or anyone else. We'll bring it back in about 15 minutes. Thank you very much.
All rise for exiting.
We are back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Ketchner on behalf of the state. William J. for Florida, State of Florida.
James Owens for Sarah Boone.
Captain Beck on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
Ms. Boone is still seated at counsel's table wearing the same clothing from this morning. Are we ready to bring in our jury for the defense closing at this time? State.
Yes, Your Honor.
Defense.
Judge, I would like you to give the audience an instruction, and then if you would, instruct the state attorney to instruct whatever family members or friends of George Torres may not be in here and may not be able to hear the instruction, but may come in during the trial so that we can try to get some order.
Are there any other members of Mr. Torres' family that may be outside that may be joining us? Okay, all right, so she's left, she's no longer here? Okay, that's what I just asked. Is there anyone outside? Okay.
She's outside, but she's not coming back in.
Okay, all right. So, members of our gallery, good afternoon. I'm going to please ask you to please contain yourself and not to have any emotional outbursts. We had a minor one, and the person, whoever it was, had a small outburst, then hid next to another family member, and then excused herself during the last during the closing. It seemed to be minor in nature. However, I'm advising everyone that at this time, if you believe that you cannot control yourself or your emotional responses during the defense's closing argument or any rebuttal by the state, I'm going to politely ask you to excuse yourselves at this time. All right, thank you very much. Mr. Owens, anything else, sir?
No, sir.
All right, state.
We're ready.
All right, let's bring back in our panel.
They're making their selections.
Okay, thank you. All can be seated. They're making their dinner selections. We'll just give them a couple minutes to do that. Thank you. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. Y'all may be seated. Members served for one of the last times, if you could, please raise your hands to confirm that you complied with the court's instructions. All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County, it's northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The team, the defense team, is here, and we're here to represent Miss Sarah Bennett. And we feel confident that we're going to be able to show you why she's not here. Okay? And I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you. And then we got a couple of videos at the end. Okay? And we're going to try our best to help you make the right decision. Okay? But yeah, Milton's a small town.
Objection. Probably is.
Overruled.
See how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. It's a very small town. We didn't know what to expect coming down here to Orlando.
Probably is.
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it, but I wanted to say. It's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised. From
Objection. Improper argument.
Mr. Owens, approach. Objections overruled.
all I wanted to say is just, since we've been here, we've been treated with respect and hospitality. And just like James Owens for Ms. Boone.
Kevin Beck.
Mr. Henderson's not going to be here for the verdict.
Okay, all right. Ms. Boone is seated at council's table. We're in the same clothing from this morning. Yes, Mr. Beck.
The judge, they've got her in chains, and they've got her in the ankle handcuffs, so she can't go anywhere. I'm just asking, we would like to rise during the jury coming in. I'm asking if there's any way we can take off the handcuffs and the waist chain so that the jury wouldn't see it in case there's something wrong with the verdict form, or there's an issue, which sometimes happens, but that's my position.
Okay. I've been advised by the sheriff that during the reading of the verdict, due to Ms. Boone's status as an inmate, their leg irons and the cuffs are to be attached.
Well, she's going to stay seated.
That's fine.
Mr. Beck's going to stay seated.
I would ask for us all to remain seated, and could you remind everybody in the gallery that there should be no emotional reactions to the
I was
verdict?
just about to address that, sir. Thank you very much. All right, members of the jury, my understanding, or members of the gallery, good evening. My understanding is that the jury in this matter has reached a verdict. I don't know what it's going to be until it's read. If you are unable to contain yourself emotionally, and you're going to react in any way, be it in joy or in sadness, I'm going to ask you politely to excuse yourself at this time. There cannot be any emotional outbursts when the verdict is read. Does everybody understand that? I see everybody nodding their heads. Okay. All right. State, are we ready to bring in our jury?
Yes, Your Honor.
Defense, are we ready to bring in our jury?
Yes, Judge.
All right, let's go ahead and bring in our jury. Everyone will remain seated.
Here we enter.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, sir.
All right, members of the jury, you may be seated. Thank you. Members of our jury, good evening. I understand that you've come to a verdict in this case.
Yes.
If you could please hand the verdict form to the deputy, please. Thank you, sir. Madam Clerk, if you could please publish the verdict.
In the Circuit Court of the 9th Judicial Circuit and in Orange County, Florida, case number 2020 CF 2603, the state of Florida versus Sarah Boone. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. So say we all, dated at Orlando, Orange County, Florida, on this 25th day of October 2024. The form has been signed by the foreperson.
Madam Clerk, please poll our jury.
Juror seat number 1, is this your true and correct verdict?
Yes, it is.
Juror seat number 2, is this your true and correct verdict? Yes, it is. Juror seat number 3, is this your true
Yes,
and
it
correct
is.
verdict? Juror seat number 4, is this your true and correct verdict?
Yes.
Juror seat number 5, is this your true and correct verdict?
Yes.
Juror seat number 6, is this your true and correct verdict?
Yes, ma'am.
Members of our jury, again, I want to thank you for your time, your sacrifice, and your attention in this matter. I know that we spent almost 2 weeks together, and it was not taken lightly, and I really appreciate the time and the effort and the sacrifice that you put into this case. I want to advise you now of your final instruction. Members, ladies and gentlemen, I wish to thank you for your time and your consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak to anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that, members of the jury, again, I thank you for your service. I'm going to ask you to return to the deliberation room. I'll be back there shortly with your jury certificates, and thank you. Ms. Boone, the jury has spoken in this matter and has found you guilty of murder in the second degree. The court adjudicates you guilty of murder in the second degree. As this is your first felony conviction, you are entitled to a pre-sentencing investigation by the Department of Corrections. Mr. Owens, are you seeking that in this case?
Yes.
Okay. State, I will order the Department of Corrections to prepare the pre-sentencing investigation. State, for the purposes of sentencing, do you anticipate eliciting any testimony from, be it the victim's family?
2 or 3 victim impact statements, sir.
Okay. Mr. Owens, do you plan on presenting any evidence during the course of the sentencing hearing, sir?
Probably some testimony from Dr. Harper.
Okay. All right. How long do you think, State, that you would need?
You mean timing-wise, or are we thinking?
A quantum of time, sir. Yeah, well, normally it takes about 30 days or so. I'm confirming with Anita as to availability. I just want to know from your side of the ledger how much time. Okay, 15 minutes. How much time do you think you're going to need to produce anything from your side of the ledger, sir? Mr. Owens.
I'd say 30 minutes.
Okay.
30 to 45.
So if we set this for an hour, that would be sufficient.
Pardon me. Okay. Stacy.
Is that sufficient, Mr. Owens?
Yes.
Okay, all right, give me a moment. Ms. Barrios is checking. Just give us a moment. We can set this matter for 1:30 in the afternoon for sentencing on December 2. State, is that acceptable? It's a Monday.
I have a status hearing, but I'll make it work.
I can move it to later if necessary.
I'm co-counsel on it. I'll make it work.
Okay. Defense.
Give me 1 minute.
Yes, sir.
That's Monday, December 2 at 1:30.
Yes, sir.
I can be here.
Ma'am, you've been adjudicated guilty. I now remand you into the custody of the Orange County Jail pending sentencing on December 2 at 1:30. State, anything else we need to address?
Not from the state.
Defense. All right. Thank you very much. We're off the record.